Yeah. All right, it's 3 o'clock, so we'll get started in an interest of time. My name is Bree Dubris. I'm one of the public health trainers for the Franklin, Hampshire Field Training Hub out of the FERCOG, and Cheryl Sbarra is here, who will be giving the presentation today. I just want to let everyone know that we always record these, and we will send the slides and the recording most likely tomorrow or sometimes early next week. And we are also offering CEUs for anyone who has their RS certificate. So that will take a little bit of time. That will probably be in a week or two that we'll send those out to everyone. And you can always find all of our recordings and these slides on either the Western Mass Public Health Association website or on our Franklin, Hampshire Field Training Hub webpage. So if you missed the email or you didn't get it, you reach out to us, but just know that you'll always be able to find these on those two web pages. So I'm going to pass it over to Cheryl, and just let me know when you're ready for me to share my screen.
I'm ready for you too. Are we all set, Bree? There we go. Okay, am I all set to start? Bree?
I think so, yes.
Okay.
I think she must have muted herself. Wait, Bree, go back to where you just had the...
Yeah, go back to the slideshow.
There, perfect.
Okay, thanks, Phoebe. Good afternoon, everyone. It's a pleasure to be with you for this hour and a half. I hope this actually is a public health power hour for you guys. I am the executive director and senior staff attorney for the Massachusetts Association of Health Boards, and I am going to speak on sort of give an update on where Massachusetts is right now in the cannabis industry. I should just start out by saying that the Cannabis Control Commission itself has undergone some real changes. The commissioners are relatively new. It's not exactly clear where the executive director is at this point. He has been with them since the beginning, since 2018, but we're not exactly sure where he is now. And sometimes when you call the commission and ask them a question, and I've heard this from folks in the field, health department staff, that they will frequently say, that's a good question. We're not sure about the answer. So you don't hold me to everything. I'm providing this for legal education, not as legal advice. You get that from your city or town attorney. But I've done a considerable amount of research on this, and this is what's up right now in Massachusetts, at least from my perspective. First slide, please, or next slide.
Cheryl, I just wanted to ask, are we going to have time for questions at the end?
Yes.
Okay, so if everyone wants to just type their questions in the Q&A box, we can read those at the end for everyone.
And I did get some questions ahead of time that I tried to incorporate into these slides. But please feel free to ask whatever you need to ask. So just a quick review of what roles city and towns play in this industry. And here's just a list of what cities and towns have the ability to do, sort of from a basic stepping off point. We can implement a local licensing process, and we can adopt and draft and adopt other cannabis related regulations, providing that they're not unreasonably impracticable. So we're going to spend some time discussing what that means and how it affects our ability to enact regulations. A city or town can also restrict the number of marijuana establishments. as long as they would permit 20% or more of the number of retail licenses. So if you have 100 retail liquor licenses, you could not restrict the number of marijuana establishments to less than 20 unless you did it at an annual municipal election. So and when I say marijuana establishment, that means, medical marijuana, retail establishments, whatever may be out there in your municipality. You also, the law states that an establishment cannot be less than 500 feet away. You can't increase that to 1,000 feet away. You can decrease it, but you can't increase it. And you can also, and we're going to talk about this in more detail, a city or town can, by an ordinance or a bylaw, authorize on-premise social consumption sites. So it's not automatic. The city council or the town meeting would have to authorize it, but it doesn't any longer have to go to vote to the whole town. Next slide. So what happened just about a year ago is that the legislature amended the adult use cannabis law, basically because what they were seeing is not what they expected to see when the adult use law was first enacted. The industry, when you took a snapshot of the industry in January of 2022, of the 346 businesses that existed at the time, only 20 of them were led by an economic empowerment entrepreneur or were connected in any way to the Commission's social equity program. So the industry is not as diverse and equitable as it was intended to be. And if you'll remember, the law was intended to provide economic opportunities for those that had been harmed by the war on drugs. But that's not what we were seeing. There were other issues with the law. We were seeing some cities and towns, not all, but some, really taking advantage of their role in the host community agreements and the community impact fees that were required by the law. And we're going to talk about that as well. And we have also seen, since the law went into effect, we have not seen one social consumption establishment open in the entire state. Next slide. So an amendment was signed into law last year, and here's a summary of the key provisions in the law. Next slide. So first, as I mentioned, the original host community agreements were really presenting a challenge. We were seeing, the big marijuana establishments and businesses and industry were really able to sort of flirt their way into a municipality by offering tons of money. They would make voluntary donations. They would go above and beyond what the law actually required them or allowed them to do. And some municipalities were just chomping at the bit to get as many of these establishments into their municipality as they could to make money. And the law wasn't clear at the time about whether the commissioners had the ability to review the agreements. The law just said that you needed, one of the qualifications was you needed this signed host community agreement. So the commission wasn't sure what to do. They said the law wasn't clear, so they determined that they did not have the authority to review these agreements to see if they were equitable. So they just said, we're not going to review them. We're just going to accept them as one of the things on the checkoff list. Okay, we have a host community agreement. Next slide. So this law, the new law, amended the whole content of the host community agreement and community impact fees. So now the costs actually have to be, the municipality has to demonstrate that the costs that they allege that they're going to occur is reasonably related to the real costs on the municipality. They have to document those costs that they allege are a result of the operation of the business. And those costs cannot exceed 3% of the business's gross sales. And these agreements themselves cannot extend past 8 years of the business's operation. And unlike in the past, the first payment is not due until the business has been in operation for a year and are now reviewing they're renewing their license. And these have to be reviewed for reasonableness and approved by the Cannabis Control Commission now. So there's no more, there's now someone who's going to be looking, or a group that's going to be looking at these agreements to make sure they're equitable. And if they're not, there will be fines imposed. Next slide. So can you just go back one for a minute? Okay. So what this basically does is it provides more oversight with these agreements. There really was no oversight of them in the past. Next slide. The law also will require that host communities implement standards and policies for social equity. And these were supposed to have been done by last month. I seriously doubt they are, since the regulations from the commission have not been enacted yet. But there will be penalties if you do not comply with the standards and policies that the Cannabis Control Commission will be outlining. Next slide. They've also created a new category called social equity businesses. So an ME stands for marijuana establishment. So establishments with the majority ownership of individuals that are eligible for either the social equity program or individuals who qualify as an economic empowerment applicant, those are considered now social equity businesses. So the social equity program is a statewide free of charge technical assistance and training program. And again, it's specifically designed for those folks who were disproportionately imprisoned and punished during and after the war on drugs. So those that have disproportionate arrests and incarcerations can utilize the social equity program free of charge to help them create a sustainable business and a way into the cannabis industry. An economic empowerment applicant is where the majority of ownership belongs to people who have lived in areas of disproportional impact for 5 of the last 10 years. And though there are 30 municipalities that are designated as areas of disproportionate impact, and you can find them on the commission's website. And I can't see the bottom of that slide. So if you are a city or town who has one or more of these social equity businesses, you will receive a quarterly distribution of 1% of the sales in that social equity business. Next slide. So the new law also, or the amended law, I should say, also sets up a cannabis social equity trust fund. And this fund is designed to provide grants and loans to those 2 social equity business types to social equity program participants and economic empowerment priority applicants. There is also in existence a marijuana regulation fund, and this is the fund that captures all of the revenue from taxes on adult use cannabis, licensing fees, penalties, any money that is derived from the cannabis industry goes into the marijuana regulation fund, and 15% of those revenues are now being directed to this social equity trust fund. Next slide. So here's what we have so far on the new social consumption law. We don't have regulations yet. Those regulations will be coming out. We're not exactly sure when, but let's talk about what we do know. Right now, as I said previously, a municipal election is no longer required in order to authorize social consumption establishments. It can be done by town meeting or by city council or town council. Interestingly and importantly, the operators of social consumption establishments are limited to those two types that we discussed, either social equity program participants or economic empowerment priority applications. So those are the only entities that can apply for a social consumption establishment license. The Cannabis Control Commission will be amending its current regulation relative to social consumption establishments. This summer, they held 3 or 4, I think it was 3 in-person listening sessions and 1 online listening session. I went to one of the listening sessions and submitted some testimony on behalf of MAHB, basically discussing my testimony, my oral testimony, and my written testimony, or our testimony was really about preemption and assuring that cities and towns would not be preempted from further regulating social consumption places. I should tell you that there overwhelmingly, and I have another colleague who attended the online hearing, and I'm sure some of you might have attended some of these listening sessions as well, but there was voluminous support for permitting combustible consumption inside of social consumption establishments. There was support for treating social consumption establishments more like bars. And the commissioners, there were 2 commissioners at the one I attended, and there was no back and forth. They were just taking testimony from folks. There will be a hearing coming up in September where MAHB will be submitting additional testimony. And there was a lot of talk of the fact that the way social consumption establishments are defined now in the current regulations is not fair, that they're still going to cost too much money to set up. They don't allow, right now, the regulations do not allow for the smoking of cannabis inside. It would have to be outside. They do allow for the vaping of cannabis inside. And it puts us in a situation that we're going to talk about on another one of these slides. But right now, the way the regulation is written, you can't smoke cannabis you can smoke. You can't smoke tobacco inside or vape tobacco inside, but you can vape cannabis inside. You just can't smoke cannabis inside. And I know there's a question about preemption. Can we go further? And we're going to talk about that in a few more slides. Next one, please. So here, and we're actually going to talk about it now. Here is the rationale originally for social consumption establishments was the fact that the law stated that no person can consume marijuana in a public place. So this is any place, including smoking bars, adult-only tobacco stores, because these places are public places. So effectively, the law bans smoking or consumption of marijuana everywhere except in a private home, and it even a multi-unit apartment building, as long as it's not public housing. So I mean, you just look at this picture here, and this is what's happening everywhere. While the law does not permit it, realistically and practically, you can't go anywhere and not smell cannabis. I mean, we all know that, and we have a private club in Worcester who is permitting it in their private club, saying it's private, and it's Worcester, so there's not a lot we can do about Worcester, unfortunately, but it hasn't caught on. There are no other private clubs that we're aware of. So because you can't smoke it anywhere except a private home or a private apartment, it becomes a social equity issue. So where if you don't own your house and you don't own a car and you live in public housing, which all public housing is smoke-free now, there's no place for you to actually consume marijuana because it's consumption, not smoking. Next slide, please. So the Mass Municipal Lawyers Association, and I'm a member of this organization, sent a letter to the Cannabis Control Commission addressing the concerns and the questions that they had about social consumption establishments. And here are some of the questions that they raised in the letter. Will there be, and I think these are things we've all thought about, will there be serving limits on cannabis? If so, how will they be enforced? How will you make sure that people are not bringing in their own products? This is an issue we have with smoking bars. Can a city or town do compliance checks for these places? Will there be any fining? How will any of these laws and regulations be enforced? What will they do about nuisance complaints? Will local health inspectors be able to inspect edibles? Will edibles be considered food? Right now, cannabis edibles are not considered food, so that locals don't have to go in and inspect. We don't know what's going to happen. One of the main complaints I heard at the listening session I was at is, what are you going to just allow Twinkies and Coke to be served in these places? They should have more options, et cetera, et cetera. Next slide, please. Will edibles be expanded? What about to go? And how will you do impairment training, roadside impairment training? Next slide. So here's where we get into some of the conundrums that still exist, even with the amendments to the new law, that are really geared toward equity and righting the wrongs that happened during the war on drugs. So here's the piece that is challenging and that we have real concerns about, because this is the first time in a law that we have seen any restriction on a Board of Health's ability to enact a regulation, as long as that regulation is reasonable. We now have a new condition for regulations related to cannabis, in that now they cannot be unreasonably impracticable. So the definition in the state law for something that is unreasonably impracticable is, as is stated here. Does it subject the owner to unreasonable risk, or require such a high investment of risk, money, time, or any other resource or asset that a reasonably prudent business person would not want to operate a marijuana establishment? That's what it says. What does it mean in practice? And next slide, please. I would bring you back to what we were discussing earlier with not being able to smoke tobacco or vape tobacco, but being allowed to vape cannabis. So here's where, you know, here's where we are concerned, because right now the statewide smoke-free workplace law, at the same time that the adult use marijuana law went into effect, simultaneously what the legislature did was it removed from the definition of smoking or non-tobacco product designed to be combusted or inhaled. The original definition in the smoke-free workplace law of smoking included or non-tobacco product designed to be combusted or inhaled. That was included in the definition of smoking, which would have captured cannabis smoking. Now the smoke-free workplace law only defines smoking as the use of tobacco or nicotine products. So it doesn't say anything about, it does not include non-tobacco product designed to be combusted or inhaled in the definition anymore. So however, a lot of our local regulations still have the more comprehensive definition in them. So the question becomes, if a local regulation has that definition, the more comprehensive definition, does that automatically mean that the social consumption establishment cannot permit the combusting or even vaping of cannabis inside the establishment? That's the $1 million question. Would a regulation that defines smoking more broadly be considered unreasonably impracticable? And I think we can make the argument that no, because the first regulation, you know, prohibited the smoking of tobacco and the smoking of cannabis inside. But I'm not sure, you know, I would imagine in this industry that it will most likely be challenged. I'm not sure. I mean, when you look at the way the regulations are written, there are many areas in the regulation where it says that cities and towns can regulate, you know, that establishments have to comply with local rules and regulations. So it's a question that's out there. And I've brought it to the attention of the Cannabis Control Commission, and they understand that, you know, from my position is that we should be able to further regulate. But again, would that type of a regulation make it so that someone coming in trying to create a social consumption establishment wouldn't want to do it because the way most folks prefer to consume cannabis is by smoking or vaping? So that's a question, and we can discuss this later. Next slide, please. So we have a few more conundrums here. We have the Federal Controlled Substance Act, which right now still has cannabis as illegal. We've had 3 different attorneys general, depending on which administration we've been in. The Obama administration said as long as this industry was complying with state law, they weren't going to touch it. Then we had the Trump administration, who revoked that memo, that standing, and said that they would be enforcing. Now we have the Biden administration, and his U.S. attorney has stated that it's not a constructive use of federal resources to enforce cannabis laws, so that it's not a priority. And we also now have, not only do we have the fact that it's still illegal federally, because it's illegal federally, it's still primarily a cash business, which again, disenfranchises those that don't have a ton of money or the ability to get a ton of money, and would have to use a bank in order to do it. There are two bills that are pending. One is the Safe Banking Act, and one is the social justice bill. But getting something passed on the federal level is even harder than getting something passed on the state level. Next slide, please. So where we are right now is that the law that was passed last year requires the commission to amend their current regulations so that they reflect the new amended law. And the feeling is that the regulations as they stand right now are too cumbersome and costly. And if you read them, they really are. I mean, they are onerous. And extremely expensive to comply with. And we've had a lot of, the smaller craft kind of businesses go to other states because they just can't comply with this. So we're seeing more of big marijuana coming into the state than individual smaller cannabis establishments. And they're clearly, from the slides you saw earlier, we need to increase the diversity. So the commission recently, just last month, approved some draft amendments to the regulations. That's just the Cannabis Control Commission that did that. They have to be completed by November 9th. A hearing is scheduled for September 8th on those proposed regulations. They have not started working on amending the social consumption pieces of the current regulations yet. They don't have the same November 9th deadline that they do for these other pieces, and we'll talk about them in a minute. Next slide. Here is what they're proposing in the new proposed amendments that we can probably get online. I haven't been able to find them yet, but I'm sure they're there. I just haven't looked hard enough. But one of the things that it does is it really opens up the hiring pool for those individuals who have criminal records that are related to cannabis. What one of the commissioners has said is that what they want to do and what the law requires them to do is move the legacy market to the legal market. And it's sort of an interesting concept because she's saying that, access to talent that brings new ideas and expertise from the legacy market is a good thing, and that employment is an effective tool for reintegration and reducing recidivism. There still are some restrictions that marijuana establishment employers can still use if someone is convicted for distributing a controlled substance to a minor, including cannabis. That would be a reason that a marijuana establishment employer could decide not to hire someone if it was that type of a conviction. Municipalities now, and this goes back to the host community agreement, municipalities cannot require these businesses to make upfront payments as a condition for operating. And when they're reviewing the host community agreement, they have to either approve or disapprove it within 90 days. Next slide. Additional proposed amendments, these are two, they would require cities and towns that have host community agreements to donate at least 3% of their community impact fee to the Social Equity Trust Fund. That will most likely be opposed strenuously by many people. We will probably see a lot of testimony on that piece at the hearing on September 8th. And again, as we said, cities or towns can affirmatively opt in to hosting a social consumption establishment through an ordinance or a bylaw now. Next slide. So what are these were some questions that I was asked to address. Why would we want to, why would we want to regulate cannabis if it's already regulated on the state level. So let's not talk about social consumption right now. We've talked about that, but let's just talk about how enforcement happens in this world. Are not, health departments are not mandated to do any enforcing when it comes to cannabis. However, we can enact local regulations as long as they're not unreasonably impracticable. Now, some of the reasons that we may want to, the cities and towns might want to regulate it is so that they can enforce. I've heard varying descriptions of state enforcement. Sometimes it's very strong, sometimes it doesn't exist. I've heard varying levels of enforcement coming from the state. So if we do have a local regulation, then we could do compliance checks and inspections, and we could assure that the grow sites are clean, and we could enforce the food code. We could enforce the food code if we wanted to. We could also address head shops. One of the changes in the law back in 2018 is that the law basically, anything that we would have considered drug paraphernalia is now a legal marijuana accessory. So what is happening is we used to require that stores that sold this type of stuff in the photo there had to have a tobacco sales permit, because what we were saying, okay, these are drug paraphernalia unless they're used for tobacco. And if they're used for tobacco, then maybe they're not drug paraphernalia. We don't have that option anymore, because now these are considered legal marijuana accessories. So there is the possibility of limiting where these products are sold. You could limit them to marijuana establishments and adult-only retail tobacco stores, or just marijuana establishments. We could also issue local permits, which would give us, better entry into the places. And again, it would be an enforcement tool. And if we set up our own local penalties for selling to someone under 21, that would be another tool in our toolbox. Next slide, please. Again, we could, because marijuana is not considered food, and I can't explain why cannabis brownie is not food. Don't ask me to explain that, because I can't. Where a brownie with CBD in it is food, but a brownie with cannabis in it is not. I can't explain that. But what we could do, Phoebe, a town would opt in. It would have to be town meeting, not select board. It would have to be the legislative body in the town, which would be town meeting. Select board doesn't have any authority over this. It would just be the legislative body. So that would be other things, obviously, that we could do would be to, if we do have operating permits, we would have the ability to suspend the permit. We could also incorporate the nuisance law into a local regulation, just for clarity, but we don't really have to do that. We can still utilize the nuisance law in cannabis issues. Next slide, please. So other strategies, we could look at some of the tobacco control strategies that we put into place. The restricting the sale of accessories to marijuana establishments. Framingham did that. I think Hudson is now considering that. Prohibit marijuana establishments from selling alcohol. I think that the CCC has already done that. But we could prohibit them from holding a local tobacco sales permit. The question becomes, these are all good things to do, but does your health department have the resources to actually enforce this? That's, again, another $1 million question. Tobacco control programs can't do it because it's cannabis, it's not tobacco. So the issue becomes, is it something that your town has the resources to actually implement. You can clearly, you could pass the regulation, but a regulation is only as good as your ability to enforce it. So it's just something to think about. So I don't know if we want to take cannabis questions right now, or if you want me to go into synthetic THC, Delta 8, Delta 10, that whole thing. I'm gonna, Bree, what is the consensus, do you think? We can go ahead and get through this all, or we can address just the cannabis right now? I'm happy to do either.
It looks like we only have 4 questions in the chat. I can't see it completely.
Okay.
So I think we could probably keep going unless.
Then let's go. And just, if they're in the chat, that's great. Put them in the chat so that we can make sure we hold on to them. And Phoebe, I will get to the templates. We do have a template for cannabis regulations. We also have a template for synthetic products like Delta 8, Delta 10, and we actually have another template for kratom. So yes, we have templates for these that we're happy to share with anybody who wants them. Okay, next slide. So switching course, but actually not switching too far off course. I'm sure that you have seen or you have heard of some of these wonderful new products that are on the market. They seem to be cropping up everywhere, and they are described as hemp-derived cannabis products. Next slide, please. So these all started popping up after the 2018 Farm Act was amended. And what the Farm Act did was to remove hemp from the definition of marijuana, which is in the Controlled Substance Act, as we talked about a little bit ago. So what's the definition of hemp in the federal law? Well, the definition is the plant cannabis and all derivatives, extracts, cannabinoids, isomers, acid, salts, whether growing or not, and this is the important part, an isomer with a delta 9 concentration of not more than 3%, 0.3%. So the definition is very specific. It addresses delta 9 concentration. That is the key. That is what hemp is. As long as something does not have a delta 9 concentration of more than 0.3%, it's not hemp, okay? It's something else. It's not hemp. So in plain language, all products that are sourced from the cannabis plant that contain not more than 0.3% of delta 9 and are a derivative extract, cannabinoid, or any of the other terms in the definition of hemp. So in order to be hemp, you have to have a delta 9 concentration of not more than 0.3%. So delta 9 and how much of delta 9 is in the product determines whether or not the product is actually hemp, which is exempt now from the definition of marijuana. Next slide. So a lot of you on this webinar will understand this and probably be able to explain it better than I can, because I didn't understand science or math. That's why I went to law school. But I'm going to try to break it down here. So what is Delta 8 or Delta 10 or any other Delta product or THC product that you're seeing out there? What actually is the driving force behind it? Well, it's Delta 8. We'll just use Delta 8 because you can use this argument for any of the other Delta products that are out there or any other synthetic hemp product. It's one of the more than 100 cannabinoids that are in the cannabis plant. So an isomer, it's also an isomer of delta 9. So what it's the same atoms, but they're arranged differently. And yes, it's found naturally in the cannabis plant, but it's found in very, very minuscule amounts. Okay, so any product you see out there, Delta 8, Delta 10, none of them are naturally extracted. They are produced in labs, they're synthetic products. And I don't know this, I learned this by doing the research, that if you were to try to produce a Delta 8 or a Delta 10 naturally, with the necessary isolation and purification that you'd need to do, you would need to process about 122,000 pounds of hemp in order to produce 2.2 pounds of naturally extracted Delta 8, and the cost would be about $22 million. So whenever you see, naturally produced Delta 8, naturally occurring Delta 8, it's not true. And one of the scientists that actually studied this said calling commercial Delta 8 THC a hemp-derived or a natural product is the equivalent of calling codeine a poppy-derived natural herbal supplement. So any product that is not a Delta 9 product cannot be produced naturally, unless you're going to do what you see in the third bullet there. The scary thing is that these products, these hemp-derived Delta 8, 10, 22, 86, are in candies, cookies, gummies. They're everywhere, and no one is regulating them. They're absolutely everywhere. Next slide. Here's just an ad that I found online. So this is claiming that it's Farm Bill compliant because it's a a hemp-derived product. So they're saying it's Farm Bill compliant. And these are the amounts that it says that they have per gummy, sort of a lot. They say that it's an extremely potent project. There are no labeling requirements. So there's no chemical analysis that's certified. These products are everywhere and we don't know what's in them. Next slide. So Josh Swider actually did a lot of testing on more than 2,000 of Delta 8 products. And first of all, they didn't even meet the Delta 9 THC requirement of having less than 0.3% of Delta 9 in them. There were only 6 out of the 2,000 that actually did have less than 0.3% of Delta 9. There were only 2 pure synthetic Delta 8 THC extract products. And the rest of what else was in the product was all sorts of stuff that you can just see there: unidentified components, bleach, solvents. And as he said, many of the producers making these products cannot carry on a chemistry conversation. That would be me. I can't carry one on. And these guys that are making these products can't either. But there is no argument about the fact that Delta 8 gets people high. Next slide. So what on earth could be our public health concerns about these products? I'm not going to read these all to you. You can see that how they're just not regulated. Okay, and they're widely available. There's a new one popping up every day. They're frequently mislabeled. We know that they can be psychoactive and impairing. The amount of THC that are in them is all over the place. Next slide. So this is a decision, and the reason that there was a lawsuit here is nothing that we're concerned about. What we're concerned about is the holding of the court. It was a trademark infringement. This brand of Delta 8 cake was saying that one company was saying that another company had violated their trademark because they were advertising these products and it looked like a cake product when it was actually another one. So it's AK Futures versus Boyd Street. They're two different manufacturers of Delta 8 products. So the question before the court was, does federal law prohibit the sale of Delta 8? Because if Delta 8 is an illegal product, then the trademark law doesn't apply because they shouldn't be selling the product anyway. So that was the issue before the court. Are these products actually legal pursuant to the Farm Act? Next slide. So here are the arguments that were made. And this is the argument that was made that, yes, these products are legal. And they're legal because the way hemp is described and defined in the Farm Act is it uses the concentration of just Delta 9 to distinguish between hemp and cannabis. So as long as the concentration of Delta 9 is not more than 0.3%, then the product by definition, according to this argument, by definition, it's hemp. And the Farm Act doesn't say anything about Delta 8. It doesn't say Delta 8 isn't hemp. It says if you have no more than 0.3% of Delta 9 in the product, then it's hemp. So it's silent. So the product was described as a hemp-derived product with less than 0.3% of the psychoactive Delta 9. So they're not going to talk about the psychoactive Delta 8 or Delta 10. The law just talks about Delta 9. So the plain meaning of the words in the law lead to the conclusion that Delta 8 is legal because it has less than 0.3% of Delta 9. Next slide. This is the argument that the DEA is making and the argument that a lot of public health advocates are making, in that the DEA claims that Delta 8 remains a Schedule I substance because of the way it's manufactured. Because it's manufactured synthetically, it remains a Schedule I controlled substance. And the fact that you need to extract Delta 8 from the plant and put it through a synthetic manufacturing process, it's synthetically derived, it's concentrated and it's flavored. And the intent of the Farm Act was to legalize only industrial hemp, which is the hemp that has not more than 0.3% of Delta 9, and not potentially psychoactive substances like Delta 8. Next slide. So here's how the court ruled. And this is very significant because this went up to the appeals court, and a court that usually is pretty liberal in its decisions. And what the court said was, no, this is a legal product. Regardless of the wisdom of legalizing Delta 8 THC products, this court will not substitute its own policy judgment for that of Congress. If the defendant is correct and Congress inadvertently created a loophole legalizing vaping products containing Delta 8, then it is for Congress to fix its mistake. So this is not controlling in Massachusetts. It's the Ninth Circuit Court of Appeals. So we're in the First Circuit Court of Appeals. So this is not binding on Massachusetts at this point, but it's concerning, and I understand where the court is coming from here. Next slide, please. So what are some strategies, and I get this question a lot, for addressing these products? And again, we do have a template, but again, I would caution, do you have the resources to actually do the enforcing? We have no state regulations. We do have, finally, a letter that you'll see in a minute from the Department of Agricultural Resources, which is the agency that's actually in charge of regulating hemp. So you could, again, age restrict the products. I mean, that should be a no-brainer to age restrict these, to require a sales permit, to require that they be behind the counter, to require that they come from an approved source that's licensed by MDAR or an equivalent if it's coming from out of state. These are kinds of things that you could do. You can also ban the sale of these products if you want, or require labeling. And labeling, no, you may end up with a First Amendment problem, but there are ways that you can regulate these products or ban the products. What's happening a lot is that we're having, a tobacco control inspector will go in and to do an inspection for tobacco, and they'll see these products and they will say, this is not a product that can be sold in Massachusetts. And the reason they can say that is, next slide, and you'll see this. This is a letter that we, after much hounding, got MDAR to actually draft that health departments are giving to retailers that are selling these kinds of products. And it's a letter that says basically what the DEA is saying, that it didn't remove these types of products from the Controlled Substance Acts because they're synthetic. So I'm just going to get rid of this. So it's basically something that enables boards of health and health inspectors to ask that these products be taken off the shelves. And if they have any questions, they can call MDAR and get some more guidance. So MDAR is relying on the DEA and saying, MDAR has prohibited the sale and manufacture of any hemp-derived Delta-8 products, and you can use it for any Delta number that you want. But MDAR is saying now that they are prohibiting these products. So that's a way of addressing these products. And then a way of addressing some of the CBD edibles that we've been seeing is CBD still is an adulterated additive for food. Unlike cannabis, it is not an approved additive for food. So those products, you can just say, this is illegal, this is a violation of the food code, you need to take this off the shelves. So that's another way of handling that. And I think that concludes my part. I can send you, Kathleen, the MDAR letter. Why don't I do this? Why don't I send it to Bree and she can send it out to everyone? And I can also send Bree the templates that I've mentioned, and she can send them out to everyone as well.
Okay, let's see if there's any questions that haven't been addressed yet. Does the new consumption law trump a municipality's regulation not allowing on-premise consumption?
That's what we talked about, and that's what we're not sure about. I think we can make an argument that it would not make it so that a person wouldn't want to come in and open up a social consumption establishment just because they can't consume combustible cannabis, especially since right now the regulation prohibits combustible cannabis. So they would be going in with their eyes wide open. The vaping one might be a little more difficult. That argument might be a little more difficult. I think ultimately it's going to be a question of whether we're preempted from doing it or not. And the only way we're probably going to find that out is, well, two ways. One, if the Cannabis Control Commission does what we will be asking them to do and clarify that this law is not preempted and cities and towns can go further, then they will have clarified that in their regulation, and that would give us a green light to, sorry, you can't smoke in here because we don't allow smoking. This is our definition of smoking, and it includes cannabis, so you can't smoke. And this is our definition of vaping, and it includes non-nicotine products, so you can't vape. So if the regulation clarifies that, we're all set. If it doesn't clarify it and it leaves it in, and they're silent, then we'll have a test case, I'm assuming, in a municipality, and we'll see what happens with the test case. So those would be the two ways it would go. We're hoping that we're not going to have a test case because we're going to get the commission to say there's no smoking or vaping inside of these establishments.
I believe this was answered, but just in case someone didn't hear it, how does the town opt in to social consumption? Town meeting vote or select board vote or board of health?
Town meeting vote or city council vote.
And will MAHB offer template board of health regs? I believe you said yes.
Yes.
How about the packaging? Many of these products look almost identical to other products in candy, and they may be purchased inadvertently.
Yeah. I mean, yes, that's one of the public health concerns here, is that they look, well, you saw the slide, they look like gummy bears. They say they're gummy bears. They're just Delta 8 gummy bears, and they're highly potent. So yeah, they're called nerdy bears instead of gummy bears in some cases. So yeah, it's really frightening that these products are mimicking other products, are not regulated, and are not age restricted. The fact that, and you will see on some of these products, they will say can't buy if you're over 18. That's just what the packaging says. That means nothing. You know, it means nothing. They're not age restricted.
So in my last community, I had a convenience store that was loaded with these. It was actually reported to me from the police department. They didn't feel comfortable enforcing it. My tobacco coalition didn't want to enforce it, which I understood because it wasn't a tobacco product. I ended up just telling them to take it down, and luckily they just did it. But
yeah, I remember that. Yeah.
If they were to fought me on that, would I technically have no leg to stand on without a local regulation at that point?
It depends. Was it an edible product?
It was all of the things you showed. It was edible, smoking, it was everything.
Well, if you don't have a local regulation, there are so many different answers to this question. If it's a flavored vaping product and it doesn't have any tobacco in it, that's still covered by the tobacco sales law. Don't ask me why. But when they amended the tobacco sales law, when the legislature amended it, they kept a very broad definition of, well, I do know why they did this, because they wanted to get at these products that they were starting to see. So if it's a flavored vaping product, the tobacco control program can fine on it because it's prohibited. And most of the vaping Delta 8s are flavored. Yeah. I don't see any that aren't. So that's one way of grabbing those, and the tobacco programs can do that. If it's an edible product, then you tell them it's a violation of the food code, and you have the authority to enforce the food code. So and again, it comes down to resources here. If it's a Delta 8 product that's not flavored, you can give them the MDR letter. And say these are still controlled substances according to the DEA and according to MDR. MDR says right in the letter, these are illegal in Massachusetts. So luckily we're not in the Ninth Circuit. So you can just say those are illegal. So it's going to depend on what the product is, what the enforcing mechanism is.
Okay, and then CBD seltzer, it's technically adulterated and it's sold everywhere. That should be illegal, correct?
Correct. It's consumed. It's a food product.
Okay. A copy of the slides, yes. And then if a Board of Health already prohibits smoking / hookah bars, can there still be a social consumption site?
That's the $1 million question. We don't know. we do know that, yes, there can be a social consumption establishment. The question is, can you smoke inside of it?
Mhm.
Yeah, they could open up a social consumption establishment and just allow edibles
Mhm.
in there, and not allow vaping or smoking. A smoking bar is not, a hookah bar has nothing to do with a social consumption establishment. There's a special license for smoking bars, and hookah bars are smoking bars, and they only permit the smoking of tobacco products. In order to have a business that allows cannabis, it has to be a business that's licensed by the Cannabis Control Commission. You can't just smoke cannabis in a smoking bar, because that smoking bar doesn't have a Cannabis Control Commission license.
Question for DPH/Mark, who's on the call. Will the Food Protection Program weigh in with the commission on edibles needing to be inspected for food code compliance?
Bree, I'm sure we'll hear from the commission at some point.
I think they may have done that already. I'll have to check. They agree that it's an adulterated product.
Yes.
I didn't mean about the CBD food. I meant about the cannabis infused edibles.
Oh, their regulation says that cannabis is not considered food.
I know, but if they're going to be having a public hearing, now is the time for our food protection program to point out that that's food and we need to be protected from bad food.
That would be something to testify on at the hearing.
Well, technically, the CCC is supposed to be inspecting for food safety under their regulations, right? Like the food isn't supposed to be completely ignored, but we just don't have the authority.
Right. It's just that you're right. It's they are supposed to, because they are required to comply with the food code when it comes to manufacturing and selling, but we don't have to enforce it. They're supposed to be enforcing it. I don't know. You folks know better than I do if they're out and about. I don't know.
Do you, this is just my question, do you happen to know what type of timeline we're looking at? Like when some of these answers about whether or not the social consumption cafes are going to allow smoking at the state level?
I will read to you the most recent. This was from August 11th. Commissioners eliminated a previously existing pilot program. This is on social consumption. I forgot to mention that. I think you all know they eliminated the pilot program, which would have initially limited social consumption sites to no more than 12 municipalities. Instead, they allowing the opt-in. Asked about a timeline for these businesses to be able to legally operate, Commissioner Bruce Stebbins, one of the commissioners leading the working group on social consumption sites, said he would like to say, in quotes, as soon as possible. We're just getting finished getting the results of a survey back, I think about a week or two ago. So our internal team is looking at the results of that survey. I also know we're doing additional work of looking at what other states have done, Stebbins said, but I will tell you that our working group continues to meet. And again, we want to try to bring something once we feel it's good to go. So your guess is as good as mine. They have not held hearings because they don't have a draft of the regulations that address social consumption yet. They are just holding a hearing on the others. And Phoebe, I don't know if they're even addressing food. The definition of food, but it's certainly something we could ask for at the hearing.
So that's all the questions we have in the chat. I don't know if anyone else has questions, but we will send out the slides, the recording from today, and then Cheryl will wait for some of your guidance documents. So
yeah, and I'm going to just fix, I saw a couple of typos in my slides. I'm going to fix them before.
Okay.
And send you a fresh set.
Okay, so it might not be until early next week, and then in the next few weeks, we'll have certificates sent out to anyone who has their RS. And if you want a certificate, even if you don't have your RS that just shows that you were here, we can also just send a certificate as well. So send me an email, which I'll put it in the chat really quick, if anyone has questions. And then our next training is in September. I believe it's September 13th. It's going to be somewhat similar today, but it's going to focus more on tobacco. And that's with Sarah McColgan from the tobacco program at the
At
state level.
MHLA. Yeah,
Yep.
she's at the Mass Health Officers Association.
Yep. And then Meredith O'Leary will also be presenting with her, and she is the she leads the Pioneer Valley Tobacco Collaborative out here in Western Mass. So if anyone has any questions, just email me, but otherwise, hopefully we'll see you in September. So thank you, Cheryl.
Sure, anytime.
Have a good
So
one.
much, Cheryl.